So, Judge, just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he used cocaine, Your Honor. Obviously. I don't think he's.
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he's not any longer. He signed up for a program, DNA testing in Genesee County. That program did not release testing results to the community corrections unless he was
positive. Hold on a second. That's not what I have. Do you have his progress report?
The one that I have, I do have a progress report. I don't
from August 28th.
I don't believe that's the date. Let me check.
Mr. Allen.
Yeah, mine dated August 28th.
In terms of his testing, I have on. So he's here on an operating while intoxicated causing death.
That's correct, Judge.
All right, and on August 20th, after his arraignment, what day was he arraigned?
I believe he was arraigned on the 16th.
So then he got tested on the 16th he was ordered. He wanted to test there. He tested on August 20th, and he's positive for cocaine.
Correct, Your Honor. I'm aware of that.
Then on the 22nd, he didn't appear for his testing.
That was when I was setting up to be tested in Genesee County. I didn't have to test again because I had just tested. I was just signing up to test in Genesee County. And I called the lady down here to let her know right away.
All right. Let's go back a moment because I don't think he's been before me.
I don't believe so, Judge. Just asking for a 2-week adjournment to see where we stand in terms of the potential.
Why is he testing positive for cocaine after getting charged and arraigned on an operating while intoxicated causing death?
Because he used cocaine, Your Honor. Obviously. I don't think he's.
No, it's a fair answer to my question. I'm just saying why.
Yes, Judge.
Why? I mean, why is he using anything?
Well, my understanding is he is not any longer.
What?
My understanding is he is not any longer, but he previously was. He began testing, transferred that testing to Genesee County per the instructions he was given at arraignment. He's been testing there, but they are not reporting the results here unless he is positive. They have not called him to test this week. He's called them twice a day to go test. They have not called him, so he went over today to community corrections and tested here. And he is going to change if the court allows
him. Tested here today?
Here this morning.
What is it? Do we have results on that?
I don't have it.
I don't have anything yet.
I was informed about it this morning myself.
So, go ahead, Mr. Green.
Thank you, Judge. So rather than do the Genesee County testing that authorized to do that does not send the reports as community corrections would require, he has signed up again today to test here and do all of his testing here, although he does not live here. He has a relative here with him who has agreed to drive him back and forth to do that testing if he is allowed, Your Honor. I understand.
What was the intoxicant in the primary offense?
Okay.
So let me get this right. He's charged. I just want to make sure. So I have it clear in my head.
You do.
He was charged with operating while intoxicated causing death.
Yes, Your Honor.
The intoxicant in that charge is cocaine.
Yes, Your Honor.
He's in arraigned. So now he knows what he's charged with.
Yes.
He's told to go to community corrections. When he gets to community corrections, mind you, 4 days later,
Yes. He tests positive.
he tests positive for cocaine.
I had some at my house, which I disposed of.
In your nose or what?
I had it in a tray and I disposed of it.
You what?
I had it in a tray
And
I
then you
threw it
just
away.
smoked it.
I threw it away.
You threw it away? How's that work? Where do you throw it? It's gonna be a long conversation. Where do you throw it away?
There was a little bit left. I used
I
it.
know.
I disposed of the tray.
You what?
I used it and then
Oh, you
of the
used
tray.
it then. Okay, so it
There was only a
didn't
little
stay,
bit.
it didn't stay on the tray.
Right.
And I disposed of the tray.
Yeah. Yeah. Okay, well.
And since then, I haven't touched it since.
What's that?
Okay, he probably stopped using because he was coming today.
Please.
And yeah,
I'm printing them now.
you're printing him. Mm.
I haven't touched it since.
So somebody needs to answer for me, why was he using after being arraigned
I mean, obviously,
on this charge? And why was he using?
I
I
don't,
have my theory, Your Honor.
I don't think there's any answer to
Oh, darn.
satisfy the court as to why.
And by the way, you're still using.
Honestly, I don't see how.
Oh,
I have,
really? Hold on.
I've never worked
You know
on
what?
it.
The thing I hate more than anything is when somebody lies to me.
Honestly, I'm not.
Okay. Well, just make sure that you, because it has to be in your system in order for you to test positive. And if it's been fine.
Counsel, approach briefly. You want to see this? That's my copy though. Yeah, this is the one he took today. No, not at all. You need all of this on the record.
And the last positive, 22nd to 7 days later.
Yeah. 7 days later. And the little bit he threw away.
Okay.
That, go ahead, I'm sorry. I'm messing up your story.
Oh, I know. But all I've done is I've used it in the chair that I saw. I've used it in the chair. And that was it.
When it's second.
No, I have not.
Okay. Well, we'll tell them that, but, you know, medically.
I know. I didn't, all I'm doing is telling you the truth.
Okay.
'Cause my-
To answer your
my
previous
question is,
question, Judge, why?
Oh, he's positive for cocaine.
Yeah, Judge. And
Just so that we know.
thank you, Judge. And to answer your previous question as to why he's still using after being arraigned,
Sure.
clearly he has a problem, Your Honor. There's no answer I can give you that can justify use of cocaine after arraignment when it's an illegal. He doesn't have any type of special license to allow him to use cocaine, Judge. So clearly he has a problem. He is willing to address that problem when he testing there. He is working and he did voluntarily come here today and take a test. So he's asking you to
Not saying that, right? No.
No, you didn't have to say.
Right, anything else?
All I can say, Your Honor.
tell you the truth.
Okay.
My cousin doesn't allow anything.
There's no way to put it in your food and drink.
It's possible. I have friends at my mother's house, but I'm cousin's house to do work down there. Okay. Because I'm gonna eventually reside down at my cousin's house.
All right. So to the positive test, Your Honor, I have no explanation aside from what he already told you.
Which positive test?
The
First one or this one?
The first positive test. Your Honor.
Oh,
The
okay.
explanation he gave you is that he used it and then threw away the tray. After he was arraigned, after he was ordered not to use, have no explanation, Your Honor. He'll just ask for mercy from the court on that, and he is willing to get any treatment that the court would allow him to take place.
Except that he can't follow the court's order. I don't know how he's gonna do treatment. And the other thing is, he doesn't test when he's supposed to test.
Yes, Judge.
So it seems to me I have two options. I could let him go and say, oh, well, best wishes. Or what I can allow him to do is go back out there, use some more cocaine and kill somebody else. allegedly. Not doing it.
Understood, Judge.
Defendant's bond is revoked. Defendant remanded to the Washington County Jail. I'll set his hearing September 2024, 9 a.m. for probable cause.
The courtroom begins quietly, but it doesn't stay that way for long. The judge is trying to understand how a defendant facing one of the most serious driving charges, operating while intoxicated, causing death, could possibly return to using cocaine almost immediately after being released on bond. The timeline is simple, yet disturbing. After being arraigned, the defendant was instructed to begin regular drug testing. Days later, the results came back positive for cocaine. Then he missed another scheduled test altogether. The defense steps in, attempting to clarify the confusion. They explain that the defendant attempted to switch to a Genesee County testing program, where results are sent only when a test is positive. They claim he has been calling in every day. They add that he even came in voluntarily this morning to test again. But none of this answers the burning question hovering over the courtroom. When the judge asks directly about the cocaine use, the defendant provides a vague and shifting explanation. First, he says he disposed of the tray. Then he admits he used what was left before throwing it away. The judge keeps circling back, trying to understand what actually happened, but each answer seems to contradict the last. At this point, the judge's patience wears thin. He makes it clear that dishonesty is a major problem, especially when the court is being asked to trust the defendant to remain free while facing a charge involving someone's death. The defense finally acknowledges the reality: there is no excuse for using cocaine after arraignment. No legal explanation exists. They openly admit the defendant has a serious problem and needs treatment. They urge the court to consider his willingness to work, test, and seek help. But the judge doesn't ignore the pattern. The defendant used cocaine after arraignment. He failed to show up for required testing. His story keeps changing, and the original offense involved the same drug. With that, the hearing takes a decisive turn. The judge outlines the dilemma plainly. He can trust the defendant to follow orders, even though he hasn't. Or he can prevent the possibility of another tragedy. The judge states he will not risk another life being lost because of more cocaine use. The decision is final and immediate. Bond revoked. Defendant taken into custody. The next court appearance is set for September 12, 2004 at 9 a.m. for a probable cause hearing. As deputies step forward, the tone in the room shifts. The defendant's earlier attempts to explain his behavior fall away. The judge's message is unmistakable. When someone ignores court orders and continues using the same drug tie to a fatal incident, the court has no choice but to act. The hearing ends not with negotiation, but with the firm reminder that accountability begins the moment someone is released on bond. And in this case, that responsibility was broken almost immediately.